I want to bring in MSNBC legal correspondent Lisa Rubin. She has been in the overflow room all morning, and then we did a very fine, I think, relay race. I handed you my pass. Did you have a chance to go into the courtroom? I'm very curious about your observations today. For a lot of people, jury instructions may seem, boring, pro forma. They are anything but. Jurors take that information into a deliberation room, and they use them as their guide. They are critical in the verdict that they ultimately come to.
Well, the word, Chris, take is a really interesting word here, because they will take the jury instructions as imported into their heads by Judge Merchan. But what they can't take is what I have in my hand right now, which are these printed out jury instructions. That is in part why Judge Merchan did something this afternoon that I personally have never seen before. The jury instructions here that are pertinent to the charged crime, that is falsification of business records in the first degree, he not only read once, he read twice in its totality. I had never seen that done before. I know at least one other lawyer affiliated with our network had never seen that done before either. And that's likely because in its repetition, he is hoping that they get what they cannot get in the jury room, which is the consultation to these words. The jury instructions largely went the way that you would expect that they would go, having watched the charging conference, which I did. And there are some wins in here for the prosecution. There are also some wins in here for the defense. And if I can, I want to outline one of them for you that I think could make a difference here. And it has to do with what it means to falsify or cause to falsify business records. The prosecution here wanted a very expansive definition of falsification that would include causing somebody to falsify business records if you set into motion a chain of events that makes it reasonably foreseeable to you that somebody else would falsify business records. That's enough to impose criminal liability, according to the prosecution's theory of the case. That's not the instruction that Judge Merchan gave, however. What he did was give an instruction on what's called accessorial liability. And it talks about when one person can be criminally liable for the acts of another, but it's not nearly as broad as the reasonable foreseeability standard that the prosecution wants. In fact, it goes like this. When one person engages in conduct which constitutes an offense, another is criminally liable for such conduct when acting with the state of mind required for the commission of that offense, he or she solicits, requests, commands, opportunes, or intentionally aids such person. So in other words, Chris, I would have to ask you or direct you to falsify a business record. It wouldn't be enough, on the other hand, that I took steps that would make it likely that I could see down the line that you were going to do that. And that may make a difference to these jurors in terms of the fact that Donald Trump didn't touch, much less create, many of the business records that he is alleged to have falsified here in this case.
And I have to say, I think they got it. And I want to give you a shout out, because we were in a car going down to court this morning. She gave me all the inside information about where the best places are to sit. And I kind of counted, and I saw, and I was exactly where you told me to sit, on the far right in the first row of the media. So thank you for that. But there was a point about an hour in. The note-taking kind of wavered a bit. People seemed, the jury seemed like maybe a little tired. A couple of them, 3 or 4 of them, were holding their heads in their hands. And then that false entry of business records came up, and I put 3 stars by it. They were very animated, once again, by that and what followed. And I want to ask you about this, Lisa. Motive and the difference between motive and intent. Did he have the motive to commit the charge? And I wonder how important you think that is. Again, I don't want to read too much into it, but jurors got animated again with those 2 points, that first one you made and then this.
Well, I think, the import here is that motive is not a necessary element of what the prosecution has to prove. At all times, they have to prove that Donald Trump had the requisite criminal intent or state of mind. But motive is the why. And Judge Merchan differentiated between the two, saying you can have intent as soon up until the moment where you take that action. It doesn't have to be pre-planned. There doesn't have to be any advanced planning. All that matters is that you intentionally take a particular action. Your motive, on the other hand, why you take a particular action, is not required for the prosecution to prove. On the other hand, can you take motive into account and determining whether it was likely that somebody had the intent? You sure can. And these jurors seem to be very interested in that, particularly because I want to call back to Josh Steinglass's closing. You'll remember that when he was talking about Stormy Daniels, one of the things he said to them was, yes, her testimony was cringeworthy. Her story is messy. And that's the whole point. She was a walking, talking proof of the fact that Donald Trump, who was distinguishing between his own sloppy words and what he considered to be the unacceptable actions of both Bill Clinton and Hillary Clinton, his opponent, while Trump was distinguishing between words and actions, Steinglass said Stormy Daniels was walking, talking proof that Donald Trump went beyond words. She was, in other words, a living embodiment of the motive here. And I think the jurors were very interested in that description. It was like her story basically explained why he wanted to cover it up. All those messy details were precisely why he wanted the American people not to hear what she had to say and all of its complexity and cringiness. And so in that respect, the fact that Judge Merchan is separating between motive, which is not required but can be helpful, and intent, on the other hand, which is an absolutely necessary element of the crimes charged here, I think is an important thing for the jurors. And my expectation, having not been in the room, is that the jurors were probably fairly attentive at that moment in the instructions as well.